Good afternoon, June 13th of 2012. Today I want to talk to you about something pertaining specifically to the Lemon Law, and that concerns situations where a consumer buys a car for less than $10,000 and buys it from a small dealership. And by small dealership, let me define small dealership for you. Obviously, if you have a big franchise dealership, like let's say a Galpin Ford. Galpin Ford is a franchise of the Ford Motor Company. They have basically a dealership license or a dealership franchise from the Ford Motor Company, and they're obviously a much larger dealership. So that would be a franchise dealership or a larger dealership. Anytime you have a dealership that has a franchise, which is a right to sell and service a specific make of car from a major manufacturer, that is a franchise dealership, and those are larger franchise dealerships. By small dealership, I'm referring to the dealerships that you drive around Los Angeles, you see the small little lots, and they'll have like 20 or 30 cars for sale, all used cars. Obviously, they don't sell any new cars. These are what I might call the smaller dealerships. So, when you've got a car purchased for less than $10,000 from a small dealership, we are recommending to our clients that they resolve their disputes in small claims court most of the time, rather than go to a lawyer, rather than file a lawsuit in court. And let me just basically tell you why. The small claims court jurisdiction within the last year went up to $10,000, meaning that you can sue another party for up to $10,000 in small claims court. There's no attorneys involved. You have to go down by yourself without an attorney. You can obviously have an attorney help prepare you for the small claims hearing, but you have to go down to the hearing yourself, and then also the other side has to show up themselves for the small claims hearing. For a smaller case, less than $10,000 car purchase from a small dealership, as a practical matter, your chances are just as good going to the small claims court as they would be hiring a lawyer. The problem with hiring a lawyer is that the lawyer, like my firm, we would sue using statutes that call for attorney's fees and so forth. As a practical matter, if there's any substantial judgment more than $10,000 taken out against the dealership, there's a substantial chance that the dealership is just going to declare bankruptcy or just fold up and go home and not bother to pay the judgment. So I mean, that's a risk you run when you take a matter into the regular court as opposed to handling it down in small claims court. So generally your chances are just as good. Obviously, just like a regular lawsuit, you have to gather your evidence, you have to bring along your witnesses. But you'll get your small claims hearing usually in 30 to 60 days after you file your small claims matter. Go down to the small claims court, try to resolve it, or pursue your judgment. But if you have a car purchase that's less than $10,000 and it's from a small dealership, we've been telling our clients and consumers to contact us. The chances are best that you're going to get a good result and also be able to collect a judgment if you go through small claims court. Obviously, there are exceptions to this rule. If there's some really aggravated fraud, like you buy a car which was salvaged and it was badly damaged in a collision, and they patch it up and they completely lie to some consumer. I mean, a really serious fraud situation. That type of situation. We would certainly take a look at that and consider filing a lawsuit. In the regular court for that type of case. Where we can seek more damages because they've done something that's obviously a lot more serious. But when your car purchase is less than $10,000 and you bought a car from a small dealership, really your chances are just as good, not only of winning but also of collecting. Part of any lawsuit is whether or not you can actually collect damages at the end of the lawsuit. If you go all the way through the lawsuit and you win, and there's no money to collect at the end because the dealer's declared bankruptcy or they've just folded up and left town, then it's been a waste of time, and that obviously does no one any good. So, car purchase less than $10,000, small dealership. We're recommending that our clients go to small claims court. You can sue for up to $10,000. Bring your evidence, bring your witnesses, but really for that type of case, for the smaller case against a smaller dealership, your chances are just as good going through small claims court as they are for hiring an attorney. And as a practical matter, I think it's a situation where you have a much better chance of getting a settlement or getting a result that you can actually live with, because if the dealer has to hire an attorney, and then if there's a larger judgment and so forth, again, you're facing a situation where the small dealership might file bankruptcy or might just leave town, making it uncollectible. So anyway, I hope this advice is helpful for you today, and Please call us if you have any questions on it. Thanks very much. Bye-bye.